everyone, welcome back to Legally Correct. I am Ruth Chanui. I'm joined with my colleagues Anthony Simiyu and Alan Ongato.
Hello.
Thank you for everyone who has been engaging with our content and commenting. So just for the new people who have just joined us, this is an initiative that aims to enlighten, educate on various areas of laws. But currently we are focusing on elections in Kenya.
In today's episode, we shall be looking at the recent amendments to the Political Parties Amendment Act. A number of changes have been introduced, and this is likely to affect the political landscape. So we thought it wise to share this with you. And Alan will start us off today.
I will start by giving the position and prior to the amendment and after the amendment. And I will discuss the Political Parties Fund, how political parties are funded. Political parties are funded using the Political Parties Fund, which receives, under the law, not less than 0.3% of the national budget. If you calculate, this is not little money. It is in billions of shillings. And this is the money that goes to Political Parties Act.
We need to start a party.
Yes, political parties.
So it's a good advice to start political parties.
Yeah, so you may consider, forming a political party and try to win an election.
Are we allowed to call it legally correct?
The registrar will have to decide. Now, it is important to note that prior to amendment, funds under the Political Parties Fund used to be distributed as follows. 80% of the funds would go to political parties proportionately depending on the total number of the total number of votes that the political party garnered in a general election, in each general election. So the registrar of political parties would calculate political party A got X number of votes for the presidential at the presidential level, and then X number of votes cumulatively at the senatorial level, like that, at the National Assembly level, like that, and then it would, compare for each political party, and then a ratio would be made, and then 80% of the fund will be distributed depending on the ratio.
So that means independent candidates have no share.
Independent candidates don't get to share in the political parties fund. So that's 80%. So it remains 20%. So from the 20%, 15% would also be distributed amongst the political parties proportionately, depending on the number of elected representatives in each party who belong to marginal special interest groups. So this is to encourage political parties to promote the welfare of members of special interest groups. So 15% will be distributed in the same way as the 80%. And then lastly, the 5% now, the remaining 5% would be used for administrative expenses of the political parties fund itself. Now, this is more critical. Prior to amendment, before a political party qualifies for a share in the political parties fund, it needed to have secured at least 3% of the total number of votes in an election. So a political party needed to have secured a minimum of 3%, at least 3% of the total number of votes to qualify to get funds from the political parties fund. In addition, a political party needed to ensure that at least two-thirds of its registered office bearers were not of the same gender. So office bearers, whether at the national level, at the county level, all of them are computed together, and then our political party needed to make sure that at least more than a third belonged to one gender. A political party needed to ensure that its governing body, which is usually the National Governing Council, is represented by members of, belonging to special interest groups. Of course, you know special interest groups are like persons with disability, youth. And then critically, and most importantly, prior to amendment, for a political party to qualify to get money from the political party's fund, it needed to make sure that it has at least 20 members of National Assembly or members of the National Assembly, at least 3 elected senators, at least 3 elected governors, and at least 40 MCAs. And of course, small parties, and you know, those 4 categories were to be read conjunctively, meaning if you had 40 MCAs, 3 elected governors, and 3 elected senators, but 19 elected members of National Assembly, you don't qualify to receive funding from the political parties fund. So the law has since been changed with the amendment, and so we go back to the 80% that would be shared proportionately depending on the number of votes garnered in the election. So under the law currently, it has been reduced to 70%. It has been reduced to 70%. Only 70% will be shared proportionately by political parties depending on the total number of votes for its elected members. And then 10% of the 80%, 10% is now being shared by political parties proportionately. They will just count how many people have been elected under your party. So party A, they'll count the number of people who have been elected, party B, the number of people who are elected, and then they'll do a ratio. And then 10% will be distributed proportionately depending on the total number for each party. The rest remain the same. 15% will be distributed proportionately depending on the number of special interest based on candidates from special interest groups, and then 5% will go to administration of the political parties fund. Critically, the requirement to get at least 3% of the votes has been done away with completely. Therefore, smaller parties have a reason to celebrate. The requirement for 3% has been done away with. The requirement for 2/3 of registered office bearers not to belong to the same gender has been retained. Similarly to the requirement that the National Governing Council or the governing body for a political party must have representation from special interest groups. Finally, and of course also one of the more important or significant changes is the requirement for 20 members of National Assembly, 3 elected senators, 3 governors, and 40 MCAs as a precondition for qualification to receive funds from the political parties fund has been amended or varied to only 1 at each level. So you only need 1 elected member of the National Assembly, 1 elected member of the Senate, 1 elected governor, and 1 elected MCA to qualify to receive funding from the political parties fund. I think I have been clear.
The other thing that has been introduced is certification of the party member list and the party list. Before, political parties could just submit it directly to the commission, to the IBC, but now with the new act, they have to first submit it to the registrar of political parties, who has to certify it. Basically, what the registrar will do is confirm if the names appearing are for the registered members of that political party. So, and for the August 2022 election, the deadline is going to be 11th June 2022. So this is a caution to the political parties.
You need to watch out that timeline.
Yes.
Also, another introduction through the Political Parties Amendment Act is a codification of the nomination process. We know we've been having the direct nomination and indirect nomination without the same being provided for under statute. Under the new act, it's now been codified, and how the nomination process is to happen is simply this way. Political parties are meant to send notices to the Register of Political Parties, notifying them whether their nomination will be direct or indirect, and to give details as regards the date when the nomination exercise is going to happen. The Register of Political Parties then will put on the registrar's website the details about the dates and the details also about how the nomination will be happening, whether it will be direct or indirect. Direct as we know it, the members of the political party convene and choose the people who will represent them for the various positions. In terms of indirect nomination, it's usually a select committee, usually the delegates, who are the ones who decide either through interviews or otherwise how the process is to happen. We saw the other day UDA, they conducted interviews. Those were the delegates who settled on their presidential candidate.
The one that there was also from third year,
Yes,
that
yes.
thing was a joke. A third year, how did she afford 1 million? The requirement of having 1 million.
The amendment has also introduced in the definition of political parties something called a coalition political party. So aside from the political parties as we knew them, the law now recognizes a coalition political party, which is several political parties coming together and reaching an agreement, and then preparing a document called a coalition agreement, which is to be deposited with the registrar of political parties, and then it will be considered as a political party for purposes of the general election. So it can front a candidate as a coalition political party, but defined as a political party under the law. So this is of course a new introduction. Some people have argued that it is just for purposes of the 2022 elections, but
Azimio.
I think
Yeah,
we know the history of
Azimio.
these things. NASA right now, you saw the other day Kalonzo came up with, Honorable Kalonzo came up with a document saying the principal parties had gone against their initial agreement. But we look forward to see how, under the new codification, how
Yes.
things will turn out.
how things will unfold.
Yeah.
New surprises every day in the
Indeed.
Kenyan political landscape.
But this act was passed out mysteriously. I think it was in November when I was hearing it was still in Parliament. Then January, suddenly it has already been, it's a law.
Mhm.
So the other thing is, as my colleague was saying, the Office of the Registrar already has a lot of roles. This act went ahead to give further roles to the Office of the Registrar. The additional functions of the registrar under the Act include to keep and maintain the register of members of the political party, of registered political parties, and then as I also stated, since they are the ones who certify the party list and member list, that's another function that has been introduced, another role, and then they also to certify that an independent candidate is not a member of any political parties. They are also required to train election agents. And another function that they are required also to regulate political party nominations in accordance to the Act.
The nominations need to be supervised a lot, otherwise problems. And that's why the Act also came up with an ad hoc committee to support the political parties disputes tribunal, at least during the elections. There is currently the political parties dispute tribunal has how many members? Five members. So there's been an addition of 18 members to join the tribunal on an ad hoc basis. This means they'll be only there for the purpose of trying to assist.
7 members.
To clear them back.
Oh, there are currently 7.
Yes.
Okay, 7 is the current number, not the initial 5 that I said. So, something tells me that the addition perhaps could be towards addressing the concerns that in 2017 we saw how overwhelmed the political parties dispute tribunal was. It was working from 6 a.m. to say at times even around midnight. You file your case in the morning, at around midnight the tribunal is sitting delivering a judgment.
It is a challenge even for lawyers who are appearing for parties there, because you'll be given 1 minute to state your client's case. What can you do with 1 minute?
They'll actually be given 1 minute.
Yes,
And I
2 minutes.
I think time in terms
Not because of time.
Yes.
But at
Every-
least this is not one good thing they
everything is
actually done.
time bound, and all disputes are being filed in Nairobi, and you have 7 members.
Then I'm imagining you're giving a judgment at midnight. Are you still even like
Yeah, perhaps that,
mistakes? I'm sure were bound to happen.
but there was an appeal mechanism. But I think we hope that the additional members will help the tribunal to address matters more effectively, and we'll have more reasoned decisions, at least with the additional manpower. And though the Act does not prescribe whether the members shall be sitting just in Nairobi, we hope that perhaps it will be time to devolve the tribunal to say, if possible, the counties,
Yeah.
And,
or to at least the big cities, maybe Mombasa, Kisumu.
to address some of these concerns, to avoid people coming from far-flung areas to Nairobi, just for a political party dispute.
Okay, another introduction, or rather omission. This one is a little suspect, at least from my eyes. Initially, there was the requirement for funds of the political parties to be audited by the Auditor General annually, and for that report to be submitted to the Registrar and to the National Assembly. But surprisingly, the amendment has completely done away with this provision, and it is so silent on that issue. So maybe
It's quite suspicious. I agree.
Yeah, but that's so suspicious. So
Considering it's 0.00 what of our budget,
0.3%
some billions
of shillings.
of public funds. I think it's something that we hope that the funds will be properly accounted for. But we'll have to make do with how things are as per the amendment.
So there was also the introduction of the expulsion of members. It wasn't an introduction really. It was not new. It was just brought in as an independent clause. Expulsion of members from a political party. So here, if a member goes against the political party's constitution, the member is expelled. But now what the Amendment Act states is that this person has to be informed of the intention of the expulsion and given a fair hearing. The aim was to promote fair administrative action.
I think related to the question of expulsion, but I know some members are just errant members, they need to be expelled. Related to the question of expulsion is the question of resignation. I think the amendments has tried to sort of give it a fresh look, I think, in terms of how the provision is introduced, resignation of members from political parties. It is introduced a clause where one is deemed as having resigned from a political party.
From their
It has
actions.
been given prominence.
So this means these are resignations other than a resignation where one voluntarily tenders a letter saying that they do no longer wish to be a member of a political party. I think it's for good order. At least there are people who, in terms of formally leaving a political party, they're not leaving the party, but their actions speak otherwise. So these actions have also been rained on. So members of political parties need to check on their conduct. They need not behave as if they are supporting agendas by other political parties which their own political party does not agree to. But of most importance is that any member who's deemed to have resigned from a political party is given that notice. But the party considers that you seem to have resigned, kindly confirm to us, and they'll be given a chance to explain themselves, at least to see whether their actions are
Invite such kind of adverse action.
scrutiny to see whether we should kick members out of political parties where they are errant.
Yeah, of course, it has consequences. Yeah, because once you are kicked out of a political party, that means you have to seek your mandate afresh. Yes. Another significant introduction in the amendment is the fact that the Political Parties Disputes Tribunal has been given the power to punish for contempt of court. Contempt of court is a serious issue, especially amongst the politicians, and as you know. And previously, that jurisdiction was only with the High Court. Was with the High Court and the lower court as well, but the Political Parties Disputes Tribunal did not have that jurisdiction. So the amendment has bestowed it with that jurisdiction, and it can exercise its power as the High Court would, to punish members for contempt. Contempt arises in instances where, say, the Political Parties Disputes Tribunal orders a certain political party to issue a nomination certificate to candidate X, but the officials issue it to Y in blatant breach, in blatant disobedience of the express orders of the PPDT. So that is why the law has come in to give it powers to take action on such officials who seek to disobey orders of the PPDT.
I think that's a good addition, that a number of tribunals don't have that power of contempt, which leaves it open for speculation whether certain tribunals can really punish parties that don't comply with its directions. Another addition that has been introduced by the Political Parties Amendment Act is the requirement that nomination exercises by political parties should be conducted on the basis of registers that have been certified by the Office of the Registrar of Political Parties. This will assist to help avoid situations where there is no formal register that is open in terms of the public accessing it to confirm who's participating in the elections. This will assist to avoid persons who are not members of the political party from participating in the elections, and in a way lend credibility to the nomination exercise.
Another one which comes to mind is the distinction that has been made prior to the amendment. Before the Political Disputes Tribunal could exercise its jurisdiction on appeal from decisions of the internal dispute resolution mechanisms, there was a requirement that you show that that dispute was actually heard and determined by the respective internal dispute resolution mechanisms. However, the law has been changed. As you may know, that kind of position was very problematic because, political parties sometimes are run by, even though they would disguise some structures, they are actually run by individuals. So when these individuals make certain decisions, then would you really expect individuals that have been handpicked by those individuals to make decisions that would go against the wishes of the owner of the political party? No. So if an internal dispute resolution mechanisms declined to hear and determine a dispute, so that meant that the party who was aggrieved did not have any recourse at the Political Parties Disputes Tribunal, because if their complaint could not be heard and determined, then the jurisdiction of the Political Parties Disputes Tribunal could not be triggered. So after the amendment, there is no an appellant at the PPDT only needs to show that they submitted, only needs to present evidence that there was an attempt to submit that complaint to the IDRM sometimes.
And I think there's a timeline that has been ascribed to it. For any complaint that a political party receives,
I think it's like 30 days.
They need to ensure that within 30 days the same is resolved.
Yes.
If not, then a party is free to move to the Political Parties Dispute
Yes.
Tribunal directly.
All it needs to show, that party needs to show, is that it submitted that dispute for resolution at the IDRM, and this will solve so many problems that the PPDT would used to encounter.
Yes.
Thank you very much for watching. In case you have any questions, please feel free to leave it at the comments section. If you have any topics that you would like us to tackle or talk about, please don't hesitate to share it with us.
Also, feel free to connect with us through social media. It's on Facebook, Instagram, LinkedIn, and Twitter. It's at Legally Correct for all of them. We leave them here at the screen. We'd love to hear from you.
Alternatively, you could also fill our free consultation form that is on our website, which is www.legallycorrect. You could also email us at hello@legallycorrect. We do look forward to hearing from you. Until next time.
Ciao, bye
Hey.
bye.